Here to discuss this subject with us is Yonatan Berman, a senior attorney in the Israeli Ministry of Justice, who has represented the Israeli government before the Supreme Court. In that position, he has litigated hundreds of constitutional and administrative cases before the court. Prior to his current role, Yonatan served as senior law clerk in the Supreme Court. He earned LLB and LLM degrees with honors from Hebrew University, and he is currently a fellow in the mid-career Wexner Fellow Program at the Harvard Kennedy School. After Yonatan's talk, there will be a Q&A session. You can ask a question at that time, either by using the chat or by using the raise hand function and then asking your question directly to Yonatan. So during the talk first, we'll ask that everybody mute themselves unless they're asking a question. And now please join me in welcoming Yonatan Berman.
Hi, thanks everyone. Thanks for the invite. As Alan said, I'm a litigator litigating cases in the Supreme Court, so I'm used to being interrupted. So feel free to interrupt me and ask questions. I think we can use the fact that this is like although Zoom, but it's still an intimate setting, so we can be happy to have this talk as a dialogue. So I'll be happy to hear your questions, or if something is not understood, I'd be happy to explain further. Okay, so I have slides, but I'm not sure I'll use them. Maybe I'll just go on and off with them because I want to see you and be able to communicate with you. What I was asked to talk about is the Israeli Supreme Court and recent cases. So I think first I want to start with giving you a basic introduction to Israeli legal system and the Supreme Court. Some of the things you might know, some of the things I'll try and make it focused on the relevant parts. But if there are things that you want to know more, just unmute yourself or ask in the chat. I'll be happy to say. So I think I'll use my slides for this part. So 1 second. Okay. See if it works. Can you see it? Thumbs up. Okay, thanks, Ruth. Okay, so this is the headline, but I think we'll talk about the Supreme Court, about Israeli legal system, and I want to talk about two main subjects, which is the political turmoil of the last year and how the Supreme Court was a part of it, or was forced to be a part of it, and the pandemic, because the pandemic in Israel, like the US, raised lots of questions of balancing between public health and basic rights. And the court also had a pivotal part in this dialogue and these questions. But first of all, okay, I won't go through this is it's a basic presentation. I think most of you know. The Knesset, 120 members, term for 4 years-ish, because it's usually 2 years, 3 years. The reason why I'm giving you this slide about the Knesset is when we're going to talk about a political turmoil and the role the Supreme Court had in cases litigated before it, it's important to understand the political framework of Israel, because the instability of recent years is a result of our system, and this also resonates with the role of the court in all kinds of cases, and specifically in cases which entail questions of governance. For example, I gave it in my presentation. Can a minister or prime minister serve when indicted? Can you have an alternate prime minister, something that we recently have in Israel? Now there's the prime minister Naftali Bennett, and there's the alternate prime minister Yair Lapid, which is a constitutional invention of recent years, which also was litigated before the court, like most questions in Israeli public life. So this is like the basic structure of the legislature. We have 120 members. We have 13 political parties, which is like you all know it, but for American years, that's like crazy, and that's a result of the system, which has like only one election area rather than districts, which are decided by majority vote, and that's why the US has only 2 parties. But the fact that it has 13 parties makes it much more complicated to build a government and to maintain a government, and all kinds of challenges. So yeah, the government in Israel is elected from the Knesset, so it's not direct elections like in the US. There was like a brief time in Israeli history where there was direct elections between 1996 and 2001, but that didn't play out as well as those who initiated the thought. So we went back to the regular system. So that means that the government, the prime minister, his government are basically comprised or are dependent on a vote of confidence from the Knesset. So as I said, we have a prime minister and we have an alternate prime minister, which is something that we'll talk about when we talk about the case that was brought forth to the court in regards to this special creature of alternate prime minister. Okay, so I'm not going to go too deep into history, but it's interesting to know that when you ask about why Israeli legal system is the way it is, it has historic components, which are sometimes they seem like absurd that we still have remnants from the Ottoman period, but it's still true. For example, the Ottomans who ruled Palestine, Israel from the 16th century to the end of World War I, had a system with personal law, which was called the millet, which each religious faction had autonomy to decide its personal law. And this wasn't changed by the British mandate from the end of World War I to the establishment of the State of Israel. And to an extent, it wasn't really changed by Israel itself. So the fact that, for example, Jews are the personal law that applies to Jews and the tribunals that decide question of personal law, of marriage, of divorce, our religious courts are not like an Israeli invention or like a Jewish invention. It's actually an Ottoman thing, which wasn't changed. Like that was the status quo and that remained. But if we look forward, we look to the British mandate, which actually only ruled Israel for, like, historically speaking, a very short period of time. It was like 30 years, even less. It's like from the mandate was established in the early 20s and the State of Israel was 1948. So it's less than 30 years. But if you look at our legal framework, our legal system is very based on English, not only English law, but the English jurisprudence, like the way law is applied, the way laws are interpreted. We're using the British common law system. Common law, also the US also has common law. It means when the courts have a much more important role in interpreting the law, in deciding case by case, in setting precedents. A precedent by court is a common law term. For example, if you look at France or Germany, which are using continental law, the judge's role is much is less pivotal, is less important, because usually they have like a codified version of the law, and the judge's role is mostly technical, taking the law, the statute, interpreting it, but the decisions, it's not like a precedent that the courts keep referring to past precedents, like, in the US, it's very, Roe v. Wade, like most Americans know, and it's a court decision. I don't think there's a parallel to it in continental law. So Israeli legal system is very similar, is very based on common law. So the role of courts, the role of precedents are important, and that's a British thing. Okay, so let's talk about, and I'd be happy if some of you want to unmute yourself or turn camera on and talk about the Israeli constitution. Does Israel have a constitution? Ruth, you're my main suspect, so unless I'd be happy to have everyone in use, but I see you and
yeah. I know Israel does not have a constitution, but it has a basic law, which is similar to a constitution, but I'd love to be reminded of the difference between those two again.
Okay, so basically you're right to an extent, but the question is, what is a constitution? Because if you look at the American Constitution, there was a constitution, and then there was the Bill of Rights, the amendments. So even in the US, it wasn't like, it happened in a very short period of time, like the first 10 amendments or so. I'm not an expert of American constitutional law, but the first amendments were really time adjacent to the Constitution itself. But it had a constitution which dealt with like the power of the president, the court, the Congress, and all that kind of stuff. And then there was the Bill of Rights. In Israel, it took like more time because the first basic laws, which were like the role of the president, of the government, of the Knesset, of the state controller, and the IDF, like there were basic laws that were set in the first days of, or the first years or decades of the Israel, and then there was like a hiatus of basic laws. And then in the early 90s, the Knesset passed two important basic laws, which is human dignity and freedom, and freedom of occupation, which are the two, the kind of the Israeli Bill of Rights. It's a very narrow Bill of Rights. It's not comprehensive as some people wanted it to be, but that's a result of political problems and challenges that still haven't been solved. But if you look historically, in the creation of the establishment of the State of Israel, they wanted, or there was a talk about doing a constitution, but they just couldn't handle it. Getting the status quo, getting a consensus of changing what was then the status quo was very complicated with religious and socialists in the early days, and also it was still a state in creation and struggling with all kinds of very brutal challenges. So they decided, there was like a decision by the Knesset to not set a one document constitution. It was a decision from early in 1950, not to write one constitution, but rather do it in chapters, basic law after basic law, and that's what the Knesset started. It did first like the regime basic laws, Knesset, president, like the first part of the American Constitution, and only in the 1990s it got to the Bill of Rights. So, but according to Israeli courts, and we'll get to it, it is a constitution. So, like, from a legal point of view, it is a constitution because it is superior to regular laws. Once you have a document which is superior to regular laws, that's a constitution, because it allows the courts to review laws and decide whether they are constitutional or unconstitutional. So from that implies the notion that it is a constitution, even though it's not in one document that you can learn by heart or I don't know, teach in your schools. But there are basic laws, and I'm going to show you some of the basic laws. So you see, you have the Declaration of the State of Israel. You have in 1958 basic law, the Knesset. You have like 1980 Basic Law Jerusalem, which was it's not a very, like, you don't usually use this law in litigation because it's more the declarative law. You have basic law government, like how to government, you have basic law judiciary. And in the early 90s, you have basic law human dignity and liberty and basic law freedom of occupation. So what, these are some quotes from these basic laws, but if you read these basic laws, you understand that they have like constitutional language. That's like the language that you can read in the American Constitution, in the Bill of Rights. It's clear that these are not regular laws, but rather statutes which are very high in the hierarchy or basic core values of the state of Israel. Okay, so just before I talk about the way the Supreme Court took these basic laws and started doing constitutional work, I'm going to say something about the Supreme Court, or about the structure of the court. So the Supreme Court is the highest court. Beneath it, there is the general law court, which is the district courts and the magistrate courts. That's, for example, if you have like a civil litigation, you're filing a lawsuit against someone. So it goes to a magistrate court, or if it's like in high money value, it goes to the district court. But civil cases, criminal cases, if you commit or you're suspected of committing a felony, you can go either to a district court or a magistrate court. It depends where, like, the severity of the felony. So the Supreme Court, one major role of the Supreme Court is being an appellate court. Like when you appeal on a decision of a district court, for example, if I was convicted of, God forbid, murder, which is something that the district court is in charge of, if I want to appeal, I would appeal to the Supreme Court. So the Supreme Court deals with appeals on district courts. There is another branch, and I mentioned it a bit when I talked about the religious courts, but there are all kinds of tribunals which are not part of the regular system on the left of this slide. That's the religious court, which I mentioned, military courts, labor courts for disputes between employers and employees are not in the regular law system, but rather in a specific system which deals with labor law, which has like a representation of employers and employees within the tribunal itself. So this is one role of the Supreme Court. But if we look at the Supreme Court, it's only half its role. The second role of the Supreme Court is being actually the first instance, the first tribunal to decide in petitions by citizens or residents or any person actually against actions of the government or parliament. And that's something very unique if you think about the American Supreme Court and the Israeli Supreme Court. Any person can file a petition which will merit a discussion or a hearing in the Supreme Court by 3 judges. So like on lots of issues, every person can file and can get his day in court in the Supreme Court. If you think about the American Supreme Court, that's a whole different ballgame because you have a very strict hierarchy of district. Like if you look at the federal level or the state level, you have hierarchy of federal district courts, of Court of Appeals in the federal level, and then the Supreme Court. And the Supreme Court actually in the US chooses what cases the court wants to be litigated. So that's something totally different. And this is a statistic that a number which is very shocking to mostly judges from other countries, but does someone know how many cases are litigated in the American Supreme Court a year? Like throw a number, how you can write in the chat or just unmute yourself. How many cases are litigated in the American Supreme Court every year?
My husband says 80.
Very close, very close. So yeah, it's more than 30 and 50. I see people writing in the chat. It's close to 100. So it's 80, 90, 100. That's the number of cases litigated in the American Supreme Court. Okay, so now the follow-up question. How many cases are litigated in the Israeli Supreme Court every year? You could write it in the chat.
10,000.
Ruth says 10,000. Any other guesses? Okay, so Ruth, you're really close. Okay, there have been years of 10,000. Recent years was like a weak year of only 9,000 cases. So if you try and compare these two, it's unimaginable. Like think about if the American Supreme Court had to hear 10,000 cases every year. So I'll like it's one of the busiest courts, like Supreme Courts in the world. But I'll just give you a small asterisk, a small comment. The American Supreme Court only sits in a full panel of 9 judges. Like every case is heard by 9 judges. In the Israeli Supreme Court, the basic case or a regular case is here heard only by 3 judges, a panel of 3. So there are 15 judges, and not all of them sit on all cases. So if you have like a very very important constitutional case, it can go to another like a panel of 5, panel of 7, panel of 9, panel of 11. I think that's the maximum that was ever. I think 11 is like the maximum. It can go till 15, but I don't think it ever went up to 15. And but still, it's very, very busy court, and it doesn't choose its cases, which is also a very important thing. It doesn't choose its cases. Like the cases that come before the court have like the right to be heard in the court. So except for a very narrow field of like civil or criminal cases, in most cases, the court has to hear the case and has to decide on the case. I'll say something about the way judges are appointed, because that's also something that is often debated in recent years about and I'll give you the difference between the American system and the Israeli system. So in the American system, the president, right, nominates, and now we're in the middle of a nomination process of Justice Jackson, but the president nominates a nominee for a post of an associate justice in the Supreme Court, and then Senate has to approve it. So it's basically a political decision, a decision made by the political branch. Okay, and if you look at judges in other levels of court, like in the federal court, it's by the president. But if you look at states, every state's like their rules vary, but there are some that are elected. Judges are elected for a term or for. So in the Israeli system, it's different. There's a committee of 9 members. Okay, in this slide, you can see like who are the members of that committee. And they choose actually all the judges, not just for the Supreme Court. They choose the judges for magistrate courts, for district courts. So it's a combination of the political branches. Government has 2 members, the Minister of Justice and another minister. The Knesset has 2 members, usually one from the coalition and one from the opposition. The current Supreme Court has 3 members, okay? So the judges have a say in electing new judges, and the Israeli Bar, the Lawyer Association, has 2 members. So if you see, it's a combination of a political decision and a professional decision. So and they have to get, like, according to current legislation, they have to get to a majority of 7 to elect a Supreme Court judge. So you have to get like a consensus, a near consensus on a nominee to get appointment to the Supreme Court. They just recently appointed 4 new justices to the Supreme Court. it wasn't a unanimous vote, but I think they got like 7 out of 9. Okay, so there have been talks in recent years about the way judges are appointed, and a discussion of maybe like there have been calls, usually in the Israeli right, to try and make it more American, like having hearings in the Knesset, like the hearings we're having now with the nomination of Judge Jackson. So this hasn't been like, usually there's a big pushback against these suggestions, but it has been talked about in recent years because people say, and we talk about cases that the Supreme Court is now litigating, and they say, okay, the Supreme Court is actually deciding very crucial things about the way Israel operates, about government. It rules out or says that certain laws are unconstitutional and like deletes them. So the call from this side of the political spectrum says, okay, so the people have a right to elect or to have a more important role in electing or selecting these judges. So that's a debate which is ongoing. I think, again, 4 judges were just appointed, so it can go into like a hibernation, but when the next set of judges retire, which is next year, it might rise and come back again to the political discourse. So also an interesting comparison with the US. I think the US now, or at least, again, I'm not a specialist of US law, but the court is divided. Like it's usually said, the court is divided. There's like the liberal judges and the conservative judges, and like many of the like contentious cases are decided along these lines. Like and now the conservatives have a majority of 6-3. So basically, so there has been talks, or there has been claims that the Israeli system, which was considered, like if you see the way they're appointed, it's supposed to be like a professional decision with a political input, but not a political decision per se. So, but there have been claims that, for example, the previous justice minister said she wanted more conservative judges. So she pushed like an agenda of appointing conservative judges. So this is also part of the current discourse, which I think Israel is not close to where the US is in like saying this judge is like this and this judge is like that, and the case will be decided. We know beforehand how the case will be decided, but there have been claims that it's going there. So that's something worth paying attention to. Any questions thus far? I'm looking at the chat to see if there's something regarding the regarding the Palestinian lands. I hope to get there. I have a slide on that. In what ways the Supreme Court changed in recent years? Okay, so that's a good question. Again, judges retire and new judges come, and this changes the dynamic of the court. I think basically the court today is not very, very different from how it was like 10 years ago. You can see new judges, like those who bring like more a conservative point of view, although there were always judges with conservative point of view, as opposed to judges who are more liberal or considered activists in the way they the dialogue of court with the government, being more activist, meaning you meddle more in the decisions of the government and you intervene more. So I think basically I don't think there has been like a major change in the dynamics of the court. Okay, so I think I answered how does the Supreme Court function without an Israeli constitution, because it actually has a constitution, or what it regards as a constitution. And are the government justices from the majority party only or from the upper? the government, okay, it's not justices, it's the members of the committee which selects judges. So I colored it. If you see, I colored the green are the one from the coalition, 2 government ministers, which are from the coalition, and 1 member of the Knesset, which is from the coalition, and usually 1 member of the Knesset, which I drew in red, which is from the opposition party. So the coalition still has like more votes than the opposition. The opposition only has 1 vote, and there have been times I actually litigated a case in, I think it was the last Knesset. I know there have been too many elections, so I stopped counting, but in one of the last Knessets, there were 2 coalition members in the committee to select judges. So, and they claimed that this was like a breach of a constitutional norm, and the court actually rejected this claim and said that there is no constitutional norm, that it has to be coalition opposition. It's more of a tradition. But I think in this Knesset, this tradition is held. There is 1 from the coalition and 1 from the opposition. And I think most political parties agree that this is a good tradition, because, you know, one time you're up, next time you're down, you want to be represented in either case. Okay. So if you have any more questions before we move on. Okay. So we talked about the function of the courts, of the court. One is being an appellate court for appeals on civil cases, on criminal cases. That's like the standard role of a court, deciding in cases litigated between, for example, 2 people, and a criminal case where someone is indicted and the court has to decide. And the Supreme Court is just where the appeal on such a decision is debated. The other branch, which I said this is the unique part, is the administrative law. Administrative by a petition attacking a decision by government. Okay, when the government decides, for example, to, I don't know, if the Knesset passes a law which someone deems is unconstitutional, or if the prime minister decides to, I don't know, nominate someone for this kind of position, then someone can file a petition to the Supreme Court, and this function is called High Court of Justice, in Hebrew, Bagatz. Okay, Bagatz, it's Bet Mishpat Gavoa LeTzedek, it's the acronym Bagatz, and that's like the function of the court when a private, like a person, files a petition against government or against the Knesset. So everyone can file a petition. That's also something very important. And to the question about Palestinians, and we'll get to it, but from the early stages, like from 1967, with the occupation of the West Bank, the Palestinians could and still can file petitions to the Supreme Court, even though they're not like citizen or residents, and actually anyone can file a petition. So that's something worth mentioning. And the claim has to be, in order for the person to get the relief he is seeking, the court should be persuaded that an action made by government is without authority, ultra vires, or unlawful or unreasonable. So it has, there are all kinds of legal claims, but basically showing that the government did something wrong. Okay, so we talked about the Constitution. Some people call it the constitutional revolution, but it's not like, you know, a revolution in the sense of, I don't know, people, battalions climbing on the Knesset or something. It's specifically a court decision from 1995. It's called Bank HaMizrahi. It's one of the big banks in Israel. And this case, again, the details are not really important because it's just that it's the first time the court says we can decide whether a law passed by the Knesset, is unconstitutional. And we can nullify it. We can say it's invalid. We can and that's a very important precedent or a ruling that till today, it's some people try to still debate it and say, oh no, the court has no jurisdiction in doing this, and the Knesset is the only one who can decide whether it nullifies laws or. But again, in the vast majority of jurists, and again, that this is what the court decide, it has the authority. So this is Bank Mizrahi, and Marbury v. Madison. I don't want to. I'm not sure. I know all the American precedents and know how to like diagnose them and analyze them in reference. But yeah, it's one of those hallmark cases which are like every law student in his first year of school has to like know, not by heart because it's like 300 pages or something, but know the different opinions. So okay, so before we get into like the subject matter, specific subject matter I want to talk about, I want to look at some questions. So Ruth asked, is the issue of Haredim serving at the IDF being reviewed by Bagatz? And again, the question is that people in the age of 18, people who go to yeshiva, ultra-Orthodox, are practically exempt from military service, unlike other. And to answer that question, definitely yes. Not only is it litigated by the High Court of Justice, the whole dynamic of the last, I think, almost 30 years of this issue has been as a result of court decisions. In the court in the 90s decided that the Minister of Defense can't just decide to exempt the yeshiva, people who go to yeshiva from military service. You can do it on your own. There has to be a law. There has to be a statute, because till then, from 1948 till the 90s, it was done by decisions by the Minister of Defense. So the first, turning the wheels in motion was a court decision, and afterwards they legislated a law which codified this exemption. Okay, so and then the court reviewed this law, and in recent rulings it decided. First, in the beginning, it gave the government more time to show that their plan is working and stuff. But recently, in the last couple of years, it decided that this is unconstitutional because it harms the right for equality of those who do serve in the IDF. So their right for equality is infringed, is harmed by the fact that so many people are exempt from military service. So definitely yes, and we haven't seen the last step of it, because now they passed new legislation, and I guess this will also be reviewed by the court, and only time will tell what would happen next in regards to this. But the court had pivotal part of turning the wheels in motion, and again, I think if you look at some of the, we talk about coalition governments and the Haredim having like a pivotal part in many governments, I think that the court's decision in these cases are sometimes caused like governments to dissolve, because when the legislation that was supposed to be the agreed upon solution was ruled as unconstitutional, then like all hell broke loose in the coalition, and because they had to re-debate all these things and find another solution. So definitely yes. Okay, any more questions? Can the court decide that marriage performed by conservative Reformed rabbis are legal? Okay, so that's an interesting question, and that's an interesting question for what purpose are they legal? Okay, because if you look at, for example, the law of return, the basic rights of every Jew or son or grandson or daughter or granddaughter of a Jew to make aliyah to Israel. So the court is the one who decided in a series of rulings from late 80s till today that I think it focused on conversions by conservative and reform rabbis, but I think that marriages performed by conservative or reformed rabbis are illegal. If you look at, for example, I don't know, I've attended many weddings in Israel performed by conservative or reform rabbis. They are not considered according to like Orthodox law. If you go to an Orthodox, again, I don't want to go into halakha, and that's a different debate. But if you look at the fact that you have to registrate these marriages, so again, the court decided way back in the 1950s that marriages that are held abroad can be registered and have to be registered in Israel, even though it's between two Jews who didn't marry by Orthodox law. So the court did have some part in ruling these issues. And if you look about conversion, then the court 20 years ago decided that conversions made by Jewish communities abroad, reform or conservative, are acknowledged and give the right of return to the person.
Marked with it.
Sorry? The person who has converted, but recently, like the past couple of years, it decided that also conversion made in Israel by conservative or reform rabbis are acknowledged for the right of return and for registration as a Jew and all that. So it can't really change the halakha if you look about the fact that still Israeli law, because of the Ottoman relics, are ruled by the status quo that wasn't changed by the state of Israel. So it doesn't change the halakha, which is what the religious courts decide by, but it has all kinds of aspects that it does decide on. Are there any limitations to the concept of standing to petition Supreme Courts? Very different US law. So basically the right of standing is whether you can file a petition, whether you are like, can anyone file a petition? So in Israel, it's basically anyone, like it's very, very wide, the issue of standing. There are some cases in which the court says, okay, if someone specific was hurt or harmed by a decision, and this complete stranger is filing the petition, so let's wait for the right, the person who was directly hurt to file the petition. And that is a set of rulings that we do see, like not because of like just standing, because maybe he's not the right person to argue this great case. Like he doesn't have all the facts, because if I was hurt because of some decision directed at me, so if Ruth filed this petition, she might not even know all the facts. So it's not just because of like standing and we only let like, it's just because it could be like a very ineffective argument. So it's very wide, but still there are some instances in which the court says, okay, no, let's wait for the right petitioner. Okay, okay, I think we passed through the questions in the chat. Okay, so now I want to, I think we have 14 minutes. So I'll just briefly, I won't talk into all of the cases, but I'll talk about two subjects which the court recently had to dive into, which is one, it's like constitutional regime issues, because the political turmoil of the last 2 years and the coalition government and the fact that the prime minister was indicted and all these stuff were, every aspect of these questions were brought forth, to the Supreme Court, and it had to decide. In some cases, it decided like, again, the decision could be like rejecting, saying that the claim is false, or saying that this claim belongs in the political sphere. But all of these issues were given to the court. So regarding the first question, can a minister, like parallel to secretary in the US, can serve when indicted? So this is a question that was actually already decided in the 1990s when Aryeh Deri, the head of Shas, was indicted for taking bribes in the 90s, and the court decides that the prime minister has to fire him. So the prime minister had to fire this minister because he was indicted of this severe felonies. So this is also something that, again, I think for not only American legal years, but it's very, very rare for, think of like the Supreme Court ordering the president to fire someone. Some would argue because in those places, usually people just decide it for themselves and it doesn't have to get to court, because if they get indicted, they just resign or are being fired. But this is a very unique decision. So the next question is, can the prime minister serve when indicted? And that actually didn't happen till this past government when Benjamin Netanyahu was indicted, and the court didn't decide on this specific questions. It decided on in the context of election, can he be in charge of forming a new government? And the court actually decided, yes, there is no legal basis for deciding that he cannot form a government when indicted. So the court said this is a decision for the Knesset. Will the Knesset give confidence? And he said it's like you can read from the tens of pages of the court decision that it says like it wants to make clear that it's not a legal decision, or based on the current framework, it's not a legal decision. And in now following these things, there is a new legislation trying to set like a rule in which if a prime minister is indicted, he will not be able to continue serving. But that's like new legislation being suggested and not what is currently the law of the land. Another question is, can the court review? We talked about basic laws, which is actually the Constitution. So the Constitution, the basic laws, give the court the right to say that regular laws are invalid, okay, or unconstitutional. But if the Knesset enacts a new basic law, can the court says that this basic law, this constitutional amendment is unconstitutional? Like, can it review the constitutional rulemaking? And the court had this, there is this law of the Israel, the nation state of the Jewish people, a law that was really contentious in recent years. So recently the court decided that it doesn't have to decide on whether it can do this kind of review, because this specific basic law is only declarative and doesn't really merit such a decision. But it did hint that if there was a basic law that was completely like ruining the basic core values of Israel as a democratic and Jewish state, then it might intervene. So, and that's also a very contentious issue. If the Knesset, as the setting the Constitution, the court can decide that this constitutional amendment is unconstitutional, it's very far-reaching. Can there be an alternate prime minister? So we have a very unique structure now at play, which was also a constitutional amendment, amending the basic law of government and enabling actually two prime ministers to take office at the same time. So when the last government was sworn in, Naftali Bennett was sworn in as prime minister, and Yair Lapid was sworn in as alternate prime minister and as prime minister from a specific date in 2023. So that's a very unique construct. And the court, it was argued that this is like an constitutional, an unconstitutional constitutional amendment because there can only be one prime minister and all kinds of basics. Like think if the United States, there was like a constitutional amendment that says that, I don't know, Donald Trump can be for 2 years and Hillary Clinton can be for 2 years. Think about this kind of imaginary things that could have been like the parallel cases. And the court decided that it's not, again, like it did about the Israel as a nation state of the Jewish people, it's not such a far-reaching, far-fetched notion that would cause the courts to intervene in basic laws or constitutional amendments. So it says, it doesn't like say that Israel is not a democracy because it has this prime minister and alternate prime minister. And also it says like it actually happened in the past. Like in the 80s, there was a period where Shimon Peres and Yitzhak Shamir did like a rotation government. They didn't change the constitution for it, but they basically did it. So it's not like something that changes the structure of the Israeli system. Okay, another issue I wanted to speak about, and I'll just, we have a couple of minutes, and I want to leave time for more questions. And I see some questions in the chat. COVID-19. So COVID-19, it was, the measures taken by governments everywhere, and in Israel, specifically in Israel, were unprecedented. In March 2020, we couldn't leave the house for more than 100 meters, like for a period of a couple of weeks. So that's totally unprecedented. Cities were being like basically barricaded and no one could enter certain cities because of COVID-19 outbreaks. And all these cases were brought to the court, which was very understanding, at least at first, for the public health issues, and gave the government like leeway to make these restrictions. I remember litigating a case, I think it was in Passover, in Pesach of 2020, where and it's interesting to do it when I'm talking to a synagogue, but closing all the synagogues, and not only that, because that also happened here, I think all kinds of states dealt with it differently, but there was no public prayer outdoors wasn't allowed. So think of the situation in which the government bans people from doing a minyan in the streets during the COVID outbreak of 2020. So, and the court decided that it didn't intervene, okay? It was a short-term measure, but still the court decided that it concluded that the government balance between the health and public health and the human rights, civic rights infringed, and it didn't find or didn't decide to intervene in this case. So that was one, and another major case I litigated was the closing of Ben Gurion Airport, which was also a very difficult decision. And the court actually, that was like in 2021, in the rise of before Delta, I think. And the court actually did intervene and says, and you can see how the court in the early stages of the pandemic chose not to intervene, and the level of intervening rose as time went by, and it decided to order the government to open the Ben Gurion Airport for more and more flights. So that's also a main challenge of the court in recent years, dealing with the pandemic and arbitrating between public health and human rights infringed. Okay, we have just a couple of minutes. I see Ruth asked about, Leon asked about the High Court of Israel can set a precedent for lower courts, but not for itself. Yes, so it's not that it can't set precedent for itself, it's just that a precedent doesn't bind the Supreme Court itself. It binds all the lower courts, but the Supreme Court itself can deviate from a past precedent. So usually they do honor past precedents because it's part of our British common law system to follow precedents. Okay, and Ruth, can I talk about my role as a litigator? No, so I'm a government lawyer. So as I said, I represented, for example, I represented the government in this case of closing Ben Gurion Airport. So I had to, someone filed a petition saying, well, you have to allow more flights, or you have to let me in. There were all kinds of petitions, let me in, let me out of Israel. And I formulated the state response, talking to the Ministry of Health, the Ministry of Transportation, the Prime Minister's office, and it was my job to litigate on behalf of the government to explain why this measure was needed, why it was proportional, why it was reasonable, and answer all the legal arguments made by the petitioners. So I argue only on behalf of the government. I don't represent private actors or petitioners. So yeah, that's my role. So again, I formulate the state response with all the other ministries. We have lots of ministries. Every ministry has its opinion, lots of opinions, and you have to combine them into one government official stand. You file the brief to the court, and then you argue the case in oral proceedings in the Supreme Court, which again is a very, very busy court. Out of the 10,000 so cases, about 3,000 are petitions, like the Supreme Court not doing appeals, doing High Court of Justice work, which is constitutional administrative law. So 3,000 cases in which a private person or organization claimed that the government has done something wrong. So that's a lot of cases, and very, very very wide set of subjects. So I talked about government issues and COVID, but I have more slides, but I think we ran out of time, which I talked about. Through it again, all kinds of basic rights, LGBTQ, equality for women, and church and state, like we talked about military service of all Orthodox men, law of return, national security, another issue which the Supreme Court has lots of cases about the security fence between Israel and the Palestinian territories, administrative detentions of suspected terrorists, military operations, and the 1967 territories. I think, don't remember who wrote in the chat, I think it was Leon, I think so. So there has been lots of litigation on all questions of settlements and building of new settlements and expropriation of lands. There was a case which I took part in litigating, which is the regulation law, which was actually a law trying to regulate or to make, to normalize private lands that were used for settlements. And the Attorney General, that was a very unique situation in which I, and my colleagues as part of the Attorney General's office, said that the government's position is unconstitutional. Like we actually argued, the government had separate private counsel speaking on the government's behalf. And we, as Attorney General, as the Ministry of Justice, gave the opposite view in court. And the court actually decided that this law was unconstitutional and ruled that it was, and actually canceled it. So yeah, I think we're at time. Again, if anyone has more questions, I'd be happy to stay on a bit further, and I want to thank you for your questions and your interest, and yeah, and have a nice weekend, sunny weekend, actually.
So I want to thank the speaker for his comments. We appreciate them very much. Very informative talk, and we wish there'll be subsequent talks, and that's it for today, I guess. And again, thank you very much for your time.
Yeah, I'll leave my email in the chat box if anyone has more questions, and I'm happy to stay on if anyone has more question. So I'm just putting in my email. Oh, I think I just sent it to David. Send it to everyone. Sorry. Okay. So do you want me to take more, like I see more questions in the chat. I don't mind taking them when we're after time, but
David?
Sure, I'm okay with that. Do you need to?
Okay, great.
so I see Ed and Allison. Are there restrictions or regulations that deal with the government officials moving to the private sectors in order to lobby? Yes, there are. There's like I think it's between 1 year that you can't like move from regulator of some sort. For example, if you work at the Ministry of Finance, or you can't move to like a private firm or private organization. And yeah, and then there's like a committee that can decide like extenuating circumstances in which it can allow it. But yeah, yeah, Ruth, hands up.
Sorry, I'm not a very fast typist, so if it's okay, I'll just ask this orally. You mentioned the law of the nation state law, and I'm using that as an example. Given the fact that it sounds like the way precedent works is different in Israel, like if a law is upheld by the High Court of Justice, can you then have subsequent petitioners who come and continue to challenge it on a different legal argument? And are there cases where, like in one case, the court makes a decision one way, but then would reverse itself on the basis of a different argument?
No, so I think it works the same like it does in like Anglo-American system. Like there's the res judicata, so which is like if the court has decided a case, it can't be reopened, and even if there's like a basically if there's like a constitutional case litigated and decided, you can't really reopen it, even if you have like a fine other argument, because then the court would say you could have brought it up till now and you haven't. So but yeah, it's the same as or similar to the Anglo-American system, in which the court doesn't rediscuss issues and it refers to the precedent. Again, if like 10 years or 20 years have passed, then the court can look at like current circumstances and decide whether you want to like re-enter the legal question.
So just to follow up on that, again, regarding the nation state law, is there any other basis of reversing it or overturning it at this point? Or is that a political issue that could be taken up by the Knesset?
Yes. So I'm not sure. I didn't litigate this case, but the court was clear that it doesn't see any cause to intervene in this basic law, it's a basic law. It's not just a law, and that makes it even more difficult to intervene because it's basically a constitutional amendment. So I don't see the court revisiting this question, and I think again, Knesset can do what the Knesset wants. Like that's up to the Knesset. But I don't see the court. I think it was relatively clear that at least in the major parts of this basic law, the court decided not to intervene. They didn't find merit to intervene in this basic law. I saw Leon, I think. Okay, anyone else? Any more questions?
Yonatan, just one other point. When you talked about
Yeah.
the law of occupation, I think you meant, that must refer to your choice of employment, not like, I mean, the use of the.
That's, occupation is a is a word with many meanings. Yeah, the basic law of it means like vocation. Yeah, like.
Yeah, I think when you talk about that, that should be made more clear to people.
Yeah, okay. That's the name of the basic law. I know, but occupy like yeah.
Right, thank you.
Okay. Okay, so thank you.
Okay, great. So I get to
Leon,
thank
I
you
think Leon
again.
is.
Leon has a question, yeah.
Yeah.
I'm sorry. I didn't understand what Ruth just said. Maybe I misunderstood what you had said. Is it fair? Do you refer to the administration of the West Bank by Israel as an occupation?
It's a humanitarian law concept. It's called the belligerent occupation. It's just the way, politically you can call it either way, like based on your political views, but the way the court talks about it, it talks about laws of occupation, and that's the way the court deals with it. So again, I don't want to. I'm not a politician, and all the views, or I don't think I actually voiced any view in this conversation. I'm usually good at not getting into it, but I think that this is a technical term, and the way the West Bank wasn't annexed to Israel proper, unlike Jerusalem and the Golan Heights. So the legal framework of the West Bank, when there's a case about it, it's international law, it's the military law, and it's the laws of occupation. It's just a legal jurisprudence, a legal field, which yeah.
So when you say courts, you meant Israeli courts.
Yeah, but in this sense, Israeli courts, like I think, yeah, it's usually like it's the High Court of Justice is the one that deals with most West Bank cases. It usually goes to the High Court. There are some cases now in the District Court of Jerusalem, but mostly the High Court of Justice.
How do you think that the courts, how do they handle this issue? Like at Sheikh Jarrah, it's so complex.
Yeah, Sheikh Jarrah is actually in East Jerusalem, so it's not considered. It's under Israeli law, and actually there was an interesting ruling last 2 weeks ago, about where the court, I think it was a majority opinion. There was also a dissent. Decided that they can stay in their houses as long as they pay like I don't know the English term, or it's kind of rent, like protected rent, which is the legal framework in which they can still live in these houses. So this was again a very contentious political issue, which was also brought forth to the court, and the court, by majority opinion, gave like a solution in which they can stay in these houses, the current residents, and they pay the due rent. So the court didn't decide; it dealt with it as a civil case. Okay, of like a dispute between two civil parties. I think the state, that the attorney general didn't. I think there was an issue with court wanted to hear the state's opinion, but actually the state didn't make an opinion. So it was actually litigated between two private actors, the residents and the the current owners. So that was like the case, and again, the litigation was like a civil case, and the decision by majority was that they can stay there if they pay their rents.
But I didn't understand what you said. I mean, Sheikh Jarrah is not in Israel proper.
Yeah, it is. Like according to Israeli,
I see.
again, politically, one can claim but according to Israeli law, Sheikh Jarrah is actually, it's a neighborhood in Jerusalem. It's actually walking distance from the Ministry of Justice where I work in Wadi Joz, which is also in East Jerusalem. It's part of Israel by Israeli law. And Israeli courts decide by Israeli law. So there is like a famous ruling in which a petitioner claimed that East Jerusalem, he claimed that East Jerusalem was illegally annexed and it's actually under occupation. And the court says like all these international claims are interesting, but we decide based on Israeli law. And Israeli law is very specific and says that Israeli law applies there. So we're in Israeli court. So Israeli court decided by Israeli law.
So that was the Jerusalem District Court decision?
No, it was Supreme Court. It was an appeal on the Jerusalem District Court, but it was actually Supreme Court. I can find. I think there's like articles about it. I think even in the New York Times I saw, but definitely in the like Jerusalem Post or like English Time or Haaretz, you can find what the role. I can try and find it.
Wow.
Okay. So thanks again, and you have my email. If you have any further questions, I'd be happy to continue. So thanks, and have a great sunny weekend.
Thank you.
Thank you.
So interesting.
Thank you, Yonatan. Thanks everyone for coming.